Welcome to VLearn Virtual Learning Network. This is session number 14 of company law and the topic is winding up. Topics to be covered are meaning of winding up and dissolution, difference between winding up and dissolution, modes of winding up, compulsory winding up, consequences of the winding up order, voluntary winding up, members voluntary winding up, creditors voluntary winding up. First, meaning of winding up. The winding up is the process of putting an end to the life of the company. It means कि जो आपका प्रोसेस है कंपनी का या लाइफ है कंपनी की, उसे वाइंड अप करना, उसे वहीं ख़त्म करना. एंड ड्यूरिंग दिस प्रोसेस द कंपनी सीजेस टू कैरी ऑन इट्स नॉर्मल बिजनेस. और इस प्रोसेस में कंपनी सीज कर देती है अपने बिजनेस को. एंड द असेट्स ऑफ द कंपनी आर सोल्ड. जो कंपनी के असेट्स होते हैं उसे सोल्ड कर देती है. एंड द प्रोसीड्स आर यूटिलाइज्ड इन पेइंग ऑफ द डेब्ट्स एंड लायबिलिटीज़. और जो उससे आपको पैसा मिलता है वो आप पे ऑफ कर देते हो डेब्ट्स एंड लायबिलिटीज़ को. एन एडमिनिस्ट्रेटर कॉल्ड अ लिक्विडेटर इज अपॉइंटेड एंड ही टेक्स कंट्रोल ऑफ द कंपनी, कलेक्ट्स इट्स असेट्स, पे इट्स डेब्ट्स एंड डिस्ट्रीब्यूट्स द सरप्लस इफ एनी अमंग ऑफ मेंबर्स. वाइंडिंग अप एंड डिसोल्यूशन. वाइंडिंग अप एंड डिसोल्यूशन ऑफ द कंपनी आर नॉट द सेम थिंग. अगर हम देखें वाइंडिंग अप एंड डिसोल्यूशन, इट डजंट मीन द सेम थिंग. इसका मतलब सेम नहीं होता. और कंपनी नॉट डिजॉल्व इमीजिएटली. जो कंपनी होती है इमीजिएटली डिजॉल्व नहीं होती ऑन द कमेंसमेंट ऑफ वाइंडिंग अप प्रोसीडिंग्स. वाइंडिंग अप इज़ द पीरियड स्टेज एंड डिसोल्यूशन इज़ द नेक्स्ट. अगर हम फर्स्ट स्टेप की बात करें तो वो हमारा वाइंडिंग अप होता है और सेकेंड स्टेप डिसोल्यूशन होता है. ऑन डिसोल्यूशन द नेम ऑफ द कंपनी इज स्ट्रक off by the registrar from the register of the company. Difference between winding up and dissolution. In winding up the assets of the company are sold. अगर winding up की बात करें तो asset जो होते हैं कंपनी के वो बेच दिए जाते हैं. and the proceeds are utilized in paying off the debts and liabilities of the company. और उससे जो भी आपको इनकम होती है वो आप यूज़ कर लेते हो डेब्ट्स और लायबिलिटीज़ को पे करने के लिए. इट इज़ द फर्स्ट स्टेज ऑफ टर्मिनेशन ऑफ द लाइफ ऑफ द कंपनी. ये फर्स्ट स्टेज होती है कंपनी की टर्मिनेशन की. वाइल द डिसोल्यूशन इज़ द नेक्स्ट स्टेज. जो अगर हम डिसोल्यूशन की बात करें तो वो नेक्स्ट स्टेज होती है. एंड आफ्टर दिस कंपनी सीजेस टू एग्जिस्ट. वाइंडिंग अप प्रोसीडिंग्स आर कैरिड आउट बाय लिक्विडेटर. जो वाइंडिंग अप की प्रोसीडिंग्स होती है वो लिक्विडेटर कैरी आउट करता है. वाइल इन केस ऑफ डिसोल्यूशन नो सच प्रोसीडिंग्स आर कैरिड आउट. Creditors can prove their debts in the winding up but not in the dissolution of the company. In the case of winding up, it is always not necessary to obtain an order of the court because voluntary winding up may take place, but for dissolution of the company, the order of the court is essential. जो अब हम डिसोल्यूशन की बात करते हैं तो डिसोल्यूशन के टाइम पे कोर्ट का ऑर्डर आना ज़रूरी है. अगर हमारे पास कोर्ट का ऑर्डर है तभी हम डिसॉल्व कर सकते हैं अपनी कंपनी को, अदरवाइज नहीं. मोड्स ऑफ वाइंडिंग अप ऑफ द कंपनी. अंडर सेक्शन 425 ऑफ द कंपनीज एक्ट, अ कंपनी मे बी वाउंड अप इन एनी ऑफ द फॉलोइंग वेज. फर्स्ट वन इज कंपनी वाइंडिंग अप बाय द कोर्ट. सेकेंड, voluntary winding up. Then it may be further classified as members voluntary winding up or the creditors voluntary winding up. Third, voluntary winding up under the supervision of the court. Now first one is compulsory winding up. Grounds for compulsory winding up. First, special resolution by the company. If the company has passed a special resolution to the effect that the company may wound up by the court, the resolution may be passed for any reason whatsoever. In such cases, the court may order the winding up of the company on the petition submitted to it. But the court power is discretionary. That is, it may not pass an order for winding up even if the company has so resolved if such winding up would be detrimental to the interest of the company or public. This mode of winding up is not very popular as members voluntary winding up is preferable because there is interference of the court is least. Second, default in holding statutory meetings. You know that the public company must hold the statutory meeting within 6 months of obtaining the certificate of commence business and file the statutory report with the registrar. If the company makes any default in holding the statutory meeting or in filing the report with the registrar, the court may order the winding up on a petition of the registrar or of a contributory. If a petition is filed by any other person, example, a creditor, it must then presented before the expiry of 14 days after the last day on which the statutory meeting ought to have been held. Next, failure to commence business. If the company fails to commence business within 1 year of its incorporation or suspends its business for a whole year, the court may order the winding up of the company only when it is satisfied that the company has no intention to carrying on business or is usable to carry on its business. Where the delays in commencing the business or suspension of business is due to temporary reasons and there are reasonable prospectus of the company starting business within a reasonable time, the court shall not pass the winding up order. Sometime a company may have a number of business units. In such a case, an interesting questions may arise as whether the suspension of any one business unit is valid ground for winding up of the company. The matter is to be decided by the court. Next, reduction in membership. If the number of members is reduced in the case of a public company below 7 and in the case of a private company below 2, the court may order the winding up of the company. Next, inability to pay debts. Inability to pay debts means that the company is not in a position to honor its monetary commitments, that is, its existing assets are not sufficient to discharge its existing liabilities. In such a situation, the court may order the winding up of the company. Just and equitable. When the court is satisfied on the fact and circumstances of the case that it is just and equitable for the company to be wound up, it may be pass an order for winding up of the company. Under this clause, the court has wide discretionary powers. What is just and equitable depends upon the facts and circumstances of each cases. Compulsory winding up. Now, who can fill a petition? Petition कौन file कर सकता है? First one is by the company. A petition can be filled by the company itself for winding up when a special resolution to this effect has been passed in the general meeting of the company. The directors or the managing directors cannot file such a petition of their own. Second, by the creditors. Creditors can file a petition to the court if he can prove that the company could not pay his debt of rupees 500 or within 3 weeks of the making the demand. The term creditors include a secured creditor, a debenture holder, a prospective creditor, and any central or state government or local authority to whom any tax etc. is due. A secured creditor holding ample securities will fail to obtain the winding up order if the position is not supported by other creditors. The creditor's petition will not be taken up if the claim of the creditors has become time barred under the Limitation Act. Next, by contributories. The term contributory means a person who is liable to contribute to the assets of the company in the event of its being wound up. A contributory is entitled to present a petition for winding up even though he may be holder of fully paid up shares or the company may have no assets at all or may have no surplus assets left for distribution among the members after paying off the liabilities. Any contributory may present a petition for winding up where the ground for winding up is the number of members is reduced below the statutory limit. Next, by the registrar. After obtaining the previous sanctions of the central government, the registrar can file the petition for winding up of the company on the following grounds. First one is if default is made in holding the statutory meeting. Second, if the company fails to commence business within 1 year of its incorporation. Next, if the number of members fall below the statutory limit. If the company is unable to pay its debts. If the court consider it just and equitable. Next, by any person authorized by the central government. If the business of the company is being conducted to defraud its creditors or members or any other person are disclosed by the report of inspectors appointed to investigate the affairs of the company, the central government may authorize any person to file a petition for winding up of the company. Usually, the registrar is authorized to present the petition. Consequences of winding up. First, after the court has made a winding up order, it must immediately send information to the official, liquidators, and the registrar. The petitioner and the company is required to file with the registrar a certified copy of the order within 30 days of the making of the order. The registrar will then notify in the office gazette that such an order has been made. The winding up the order shall be deemed to be notice of discharge to the officers and employee of the company, except when the business of the company is continued. No suit or legal proceeding against the company could be commenced or proceeded with after the making of the winding up order, except with the leave of the court and subject to such terms and conditions as the court may impose. Voluntary winding up. Section 484 of the Companies Act specifies the circumstances in which company may wound up voluntary. First one is by passing an ordinary resolution where the period, if any, fixed for the duration of the company by the article has expired, or where the article provides that the company is to be dissolved on the occurrence of any event and if that event has occurred. Second, by passing a special resolution. That means the company will be wound up voluntary. When a special resolution is passed by the members to wind up the company, it is not necessary to give any reasons for doing so. When a company passes a special resolution for voluntary winding up, it must within 14 days of the passing of the resolution give notice to the resolution by advertisement in the official gazette and also in some newspapers circulating in the district where the registered office of the company is situated. Members' voluntary winding up. First is declaration of insolvency, where it is proposed to wind up a company voluntary. The declaration of insolvency is to be made by all the directors or by the majority of directors. The declaration must be made at the meeting of the boards and must be verified by an affidavit. The declaration must state that the directors have made a full inquiry into the affairs of the company and that they have formed the opinion that the company has no debts or that it will be able to pay its debts in full within such period not exceeding 3 years from the commencement of winding up. The declaration shall be effective only if it is made within 5 weeks immediately before the date of passing of the resolution of winding up the company and is delivered to the registrar for registration before the date. Second, product of winding up. The company in a general meeting shall appoint one or more liquidators and fix his remuneration, and liquidators so appointed will take charge only after his remuneration is fixed. The company is required to give notice to the registrar of the appointment of the liquidator within 10 days of such appointment. The powers of the board of directors shall cease on the appointment of a liquidator except when the company or the liquidator sanctions their continuance. Last is final meeting and dissolution. When the affairs of the company are fully wound up, that is, when all the assets have been disposed of and realized and all debts and liabilities have been discharged, the liquidator shall call a general meeting of a company and lay before it the accounts of winding up to show how the winding up has been conducted and the property of the company deal with. This is final meeting of the company. Creditors voluntary winding. First one is meeting of creditors. The company must call a meeting of the creditors to be held either on the same day on which the meeting of the company is to be held or the day following the day when member meeting is held to pass resolution for voluntary winding up. The board of directors shall lay before the creditors a full settlement of the position of the affairs of the company together with a list of the creditors of the company and the estimated amount of their claims. Second, appointment of liquidator. The creditors and the members at their respective meetings may nominate a person to be the liquidator. Where the members have not nominated any person, the nominee of the creditors shall be the liquidator. Where different persons have been nominated by the creditors and the members, the creditors nominee shall be the liquidator. Last, committee of inspection, that is COI. The creditors at the meeting may appoint a committee of inspection consisting of not more than 5 persons, to which the company may also appoint 5 members. In case of any difference of opinion as to the nominee of the committee of inspection, the court shall settle the matter. The remuneration of the liquidator shall be fixed by the COI or the creditors, failing which it shall be determined by the court. Now there are some questions on the basis of this session. First one is, what do you mean by voluntary winding up? And second one is, list 2 circumstances in which company may be wound up voluntary. Thank you. Happy learning. We learning.